Understanding hallucination complications in AI-driven legal practice. Hallucination complications. Asterisk at a glance asterisk. Lawyers who integrate artificial intelligence, AI, tools into their legal practices must ensure that every output is meticulously reviewed and validated. Neglecting this responsibility could lead to regulatory scrutiny and potential gaps in professional indemnity insurance coverage. To alleviate these risks, law firms should establish internal guidelines for the use of AI, which should include mandatory verification of all content generated by AI. Additionally, training programs should be developed to inform legal professionals about the limitations of AI tools and the critical need for human oversight. Insurers may also need to reassess their policy language to keep pace with the rapidly changing landscape of legal technology. This could involve adding specific endorsements for risks associated with AI or clarifying exclusions that define the limits of coverage. The hallucination-induced complications. A recent surge in court rulings, both domestically and internationally, has highlighted instances where case law references presented in arguments simply do not exist. This phenomenon is often referred to as AI hallucination. One pressing question that emerges from this legal evolution and the increasing reliance on AI in legal practice is whether a client could successfully claim professional negligence against an attorney if the attorney's dependence on AI-generated content contributes to an unfavorable judgment or order. Duty of care. Legal practitioners owe a duty of care to their clients, which encompasses the responsibility to verify the accuracy and reliability of all legal submissions, irrespective of their origin. If an attorney utilizes unchecked fictitious case law or misleading arguments generated by an AI tool, and this significantly impacts the outcome of the client's case, the client may argue that the attorney did not meet the expected standard of skill and diligence of a competent legal professional. This situation could potentially lead to a delictual or contractual claim for damages, especially if the client experiences financial or reputational harm due to the attorney's negligence. The presumed comfort of insurance. When confronted with a negligence claim, an attorney will likely turn to their professional indemnity, PI, insurers for protection. PI insurance is specifically designed to shield legal practitioners from claims arising from negligence during their professional activities. After addressing whether a client has a valid claim against an attorney, another critical question arises. Does the attorney's PI insurance cover negligence that stems from the use of AI tools? While PI policies typically cover negligence by legal practitioners, they often include specific exclusions or limitations and require the insured to act with due diligence and take reasonable steps to prevent or mitigate losses. The discomfort of rejection. In cases where an attorney relies on AI-generated or hallucinated content, such as fictitious case law, without verifying its accuracy, insurers may contend, and would be justified in doing so, that this represents a failure to meet the obligation of taking reasonable steps. The situation becomes even more complex when considering the evolving nature of AI tools. Unlike junior attorneys or paralegals, AI systems are not regulated, licensed, or bound by professional codes of conduct. AI does not undergo testing to pass board exams, nor does it need to apply for admission to the profession as a qualified individual. This lack of accountability may prompt insurers to categorize AI-related errors as falling outside the scope of traditional coverage, unless the policy explicitly addresses technology-related risks. In such instances, the error may be viewed as a result of the practitioner's negligence rather than a fault of the AI tool itself. The use of unverified AI tools, especially those prone to hallucinations, is likely to be interpreted as a violation of the professional duty to act with reasonable care and skill, leading insurers to likely reject PI claims of this nature. A cautionary tale. Attorneys who choose to incorporate AI tools into their practices must proceed with caution, ensuring that all outputs are thoroughly reviewed and validated. Failing to do so could not only expose them to regulatory scrutiny, but also leave them without the protective coverage of their PI insurance if issues arise. To mitigate these risks, law firms should consider establishing internal protocols for AI usage, including mandatory verification of all AI-generated content. Training programs should be designed to inform legal professionals about the limitations of AI tools and the necessity of human oversight. Insurers may also need to revisit their policy language to adapt to the evolving landscape of legal technology. This could involve specific endorsements for AI-related risks or exclusions that clarify the limits of coverage. The South African Law Reform Commission may also play a pivotal role in shaping future regulations. As AI becomes increasingly integrated into legal practice, statutory guidance will be essential to delineate responsibilities and liabilities. The integration of AI into legal practice presents significant potential, but it also introduces intricate risks. The repercussions of AI hallucinations can be severe, both professionally and financially. Whether insurers will cover attorneys in such scenarios largely depends on the wording of the policy, the nature of the error, and the measures taken to mitigate risk. Until clearer guidance is established, attorneys and advocates should regard AI as a tool, rather than a replacement, for professional judgment. Insurers, on the other hand, must confront the reality that the future of legal risk is no longer solely about human error. The information and materials published on this website are intended for general informational purposes only and do not constitute legal advice. We strive to keep the content updated regularly to provide the most current and accurate information. For specific legal issues or matters, please consult one of our lawyers. We accept no responsibility for any loss or damage, whether direct or consequential, that may arise from reliance on the information contained in these pages. Please refer to our full terms and conditions. #subscribe. We support our clients' strategic and operational needs by providing innovative, integrated, and high-quality thought leadership. To stay informed about the latest legal developments that may impact your business, subscribe to our alerts, seminars, and webinar invitations. South Africa's legal regulator takes action against AI misuse in law. Imagine a courtroom where artificial intelligence fabricates evidence, creating chaos in the justice system. This isn't science fiction, it's happening now in South Africa, and it's sparking urgent conversations about how to regulate AI in the legal profession. The Legal Practice Council, LPC, which oversees attorneys, advocates, and aspiring legal professionals in the country, is currently drafting an AI policy after two alarming incidents involving fake case law made their way into court filings. These scandals have raised serious questions about the use of AI tools in legal practice, and the potential consequences for the integrity of the justice system. The cases that triggered this regulatory push involved fabricated judicial decisions, entirely invented by AI tools, that were cited as legitimate precedents. In one instance, a legal practitioner referenced a non-existent ruling in *Mervendleller v KZN MEC for Cooperative Governance *. Similarly, another fictitious judgment appeared in * Northbound Processing v SA Diamond Regulator *. Both cases were flagged and referred to the LPC for investigation. Llewellyn Curlewis, deputy chair of the LPC, didn't mince words when he described the gravity of the situation. This could undermine the entire foundation of our justice system. So, what does this mean for lawyers using AI? According to Curlewis, every single piece of information generated by AI must be rigorously verified before being included in any legal submission. But here's where it gets controversial. Should the legal profession embrace AI as a tool for efficiency, or should it treat it with extreme caution due to its potential risks? While AI can streamline research and document preparation, the dangers of misuse are undeniable. Even unintentional errors, such as failing to verify AI-generated content, could lead to severe disciplinary actions, including disbarment. South Africa's legal system is built on the doctrine of precedent, meaning past rulings heavily influence future decisions. This makes the misuse of AI particularly concerning, as fabricated case law could ripple through the courts, distorting outcomes, and eroding public trust. To address these challenges, the LPC is collaborating with IT specialists and academic institutions, which are themselves wrestling with the implications of generative AI. Universities across the globe are already grappling with issues like plagiarism and falsified research outputs caused by AI tools. By tapping into their expertise, the LPC hopes to craft a framework that balances innovation with ethical responsibility. But crafting enforceable guidelines won't be easy. AI is still a relatively new and rapidly evolving technology, making it difficult to regulate effectively. Despite these challenges, the LPC is determined to create a policy that safeguards the rule of law while encouraging responsible use of AI. We're not trying to stifle innovation, Ikerluis explained. We just want to ensure that new technologies enhance, rather than harm, public confidence in the legal system. And this is the part most people miss. The debate isn't just about regulation, it's about trust. If the public begins to doubt the reliability of legal proceedings because of AI-related blunders, the consequences could extend far beyond individual cases. Could unchecked AI use in law lead to a crisis of confidence in the justice system itself? That's a question worth pondering. As the LPC works toward finalizing its AI policy, it invites input from all stakeholders, including legal practitioners, academics, and even the general public. What do you think? Should AI be embraced as a revolutionary tool in the legal field, or does it pose too great a risk to the integrity of justice? Share your thoughts in the comments below. We'd love to hear your perspective. AI hallucinations in legal cases. What you need to know. Are you ready for a wild twist in the world of legal proceedings? Recent events reveal that seemingly ordinary health issues can lead to unexpected complications, including hallucinations in legal documents. Yes, you read that right. But here's where it gets intriguing. On June 20, 2025, the case of Pro Health Solutions Limited v Pro Health Inc., 2025, 6 WLUK 622 made headlines as it reached an appeal before the appointed person, AP, in the Trademarks Registry. The essence of the conflict revolved around trademark registration and invalidation, with the appellant, representing himself, contesting a prior decision that benefited ProHealth Incorporated. Although the appeal was ultimately rejected, the case drew attention for its in-depth exploration of using generative artificial intelligence, AI, in legal submissions, particularly the phenomenon of fabricated citations, often referred to as hallucinations. These hallucinations are the unfortunate shortcoming of large language models like ChatGPT, which can sometimes produce outputs that are completely inaccurate and don't align with the factual information they were trained on. The spotlight was on the appellant, who, without legal representation, relied on ChatGPT to draft his appeal and skeleton argument. While the cases he cited were legitimate, the documents mistakenly contained quotations that were never part of the actual judgments and, in some cases, misrepresented the original rulings. Surprisingly, the appellant openly admitted his reliance on AI and expressed regret for the inaccuracies. Conversely, the represented party, ProHealth Incorporated, aided by a trademark attorney, faced its own challenges. Though the cases referenced were valid and correctly noted, the attorney struggled to pinpoint the specific elements of the judgments that validated his legal claims. When pressed during the hearing, he faltered, unable to provide the necessary support for his arguments. After the hearing, he attempted to clarify via email, but this did little to improve the situation. Warnings and guidance on AI use. As pointed out by my colleague Fiona, the AI hallucinations issue is rapidly becoming more prominent in the legal landscape, with actual sanctions being implemented against parties that mislead the courts. A notable reference was made to the case of Frederick Ainde v. the London Borough of Haringey, 2025, EWHC 1040, which the AP referenced in light of this incident. The AP made a distinction between genuine errors or misunderstandings of the law and the serious ramifications of depending on fabricated legal authorities. They stressed that all parties, regardless of their experience or level of representation, hold a responsibility not to mislead the tribunal by submitting false citations. This point became especially complicated in the current case. However, rather than imposing sanctions, the AP suggested avoiding penalties and instead recommended a change in practice. They proposed that the registrar should include clear warnings in all correspondence that solicits submissions, skeletons, or other documents. These warnings should explicitly outline the risks associated with using AI for legal research or drafting submissions, as well as the potential consequences for those who present fabricated citations to the registrar or the appointed person. Implications. Imagine facing a similar situation. It's enough to make anyone anxious. However, this ruling should not drastically alter your approach to legal matters. Instead, think of it as a friendly reminder that generative AI is not a reliable stand-in for the thorough analysis provided by a qualified legal professional. We're keen to see if the registrar heeds the AP's suggestion to develop clearer guidance moving forward. Remember that this article serves as a general overview of the topic. For tailored advice specific to your situation, it's wise to consult a legal expert.